I'm James Swartz, managing attorney at Swartz & Swartz. So when you pursue a personal injury claim, there are a number of different types of damages that are recoverable. One type is known as pain and suffering. So what does that really mean? Pain and suffering damages relate to both emotional and physical damages stemming from the happening of an incident. So for example, they might include not only physical pain, but fear and worry in the future, again, relating to the injuries suffered in an accident. Now, one of the more challenging aspects of pain and suffering damages has to do with how those damages are calculated. Now, a jury in a jury trial will consider what they deem to be fair based on their personal experiences and based on the evidence that's presented in the case. So there's not really one way that these types of damages can be determined or calculated. Having said that, insurance companies will often try to add some certainty to the calculus and try to come up with ways to determine what the value of pain and suffering damages might be in any given case. One method used by insurance companies is known as the multiplier method. So what does that really mean? Let's say there are $100,000 in known and calculable damages in a personal injury case. And in addition, let's say the multiplier used by the insurance company is 1.5. In that instance, the insurance company would assess $50,000 towards the pain and suffering damages for a total value of $150,000. Now, that method is not certainly a method that's agreed to or preferred by plaintiffs and their attorneys. However, it's important to understand how insurance companies are going to approach these matters so that you and your attorney can provide an effective counter to what the insurance company is trying to do. Another method for calculating pain and suffering damages is known as the per diem method. So that means literally placing a value on the pain and suffering endured by the plaintiff day to day to day. Now, in a case where that pain and suffering has a limited duration, say a month, that pain and suffering calculation, of course, will have an endpoint and there'll be one number. In other cases where there are very serious injuries that might last a lifetime, the insurance company or even some plaintiff's attorneys at jury trials will present to the jury the per diem method of calculating pain and suffering over the course of a lifetime. Now, in serious injury cases, insurance companies don't like that method too much because the damages tend to be higher. Yet another method used by insurance companies is known as a hybrid method, where essentially these two versions of calculating damages, that is the per diem method and the multiplier method, are used together to result in a number for pain and suffering. Finally, insurance companies will often employ, especially these days, a software program which incorporates different data points, including the nature of the injury, the seriousness of the injury, even other verdicts and settlements around the country and in your jurisdiction. Regardless of which method your insurance company uses or your attorney might use to determine damages in your particular case, it's important to understand that it's left to the discretion of juries, again, based on all the evidence presented at trial, how to calculate pain and suffering damages. So if you've been injured in an accident and have questions about pain and suffering damages, contact Swartz & Swartz.